Okay, ever get that sinking feeling? You know when like someone owes you money and they're just like ignoring you? Like you sent reminders, maybe even like considered like, one of those letters. But still nothing. It's so frustrating. Right.
Absolutely.
Well, today we're going deep into what happens when someone in the UK refuses to pay even after a CCJ or county court judgment has been issued.
Yeah.
And we've got your research right here ready to sort of unpack all those legal options and strategic considerations when you're navigating this tricky situation.
Yeah, it's interesting you bring up that feeling of frustration because often, like, that's precisely the leverage a CCJ provides.
Right.
Think of it this way. A CCJ isn't just a demand for payment. It's a formal declaration entered into like a public register that this debt exists and that record can like have ripple effects on the debtor's financial life for years to come.
So it's like a public shaming for bad debtors.
Not quite public shaming.
Okay.
The impact on their credit score is undeniable. Imagine trying to get a mortgage, finance a car, even rent a flat with a CCJ hanging over your head.
Right.
It suddenly becomes much harder to participate in like everyday financial transactions.
Okay. So we've established a CCJ carries some serious weight.
Yeah.
But let's say the debtor is either incredibly stubborn or just completely oblivious.
Right.
What's the next step for someone stuck with an unpaid CCJ?
Okay, so before jumping into the enforcement actions, which we'll get to, there are some crucial initial steps. First, you want to send a formal reminder letter after that CCJ payment deadline is missed. This isn't just a friendly nudge. It's a documented communication that reiterates the seriousness of the situation and the potential consequences of continued non-payment.
So it's like, hey, this isn't going away, pay up, or things are about to get real.
Exactly. And this is where meticulous record keeping comes in. Keep copies of everything. Letters, emails, notes from phone calls, even proof of postage. Mm-hmm. It's all about building that solid paper trail, just in case you need to escalate things further.
All right, let's say the reminder letter falls flat. What's next in the arsenal of debt recovery tools?
Now we get to the toolbox of enforcement methods, each with its own pros and cons, depending on, the debtor's situation.
Okay.
One option is the attachment of earnings order.
Okay.
This is particularly effective if the debtor is employed and receiving regular wages. It's like a direct debit, but with a court order behind it, ensuring that a portion of their earnings goes directly towards settling the debt.
So you're essentially cutting out the middleman and grabbing the money right from the source. Yeah. Sounds pretty efficient.
It can be, yeah.
But what if the debtor is self-employed or doesn't have a steady income?
That's where we might consider a warrant of control. This involves authorizing a bailiff to visit the debtor's property and seize goods to be sold at auction to cover the debt.
Whoa, sending in the bailiffs.
Yeah.
I bet that gets people moving.
It can.
But what if they don't have anything of value or they just refuse to open the door? Surely there are debtors out there who are savvy enough to make this tactic pretty ineffective.
You're right. It's not a foolproof method. That's why there are other options, like a charging order.
Okay.
This places a legal charge on the debtor's property, typically their home.
Right.
It means the debt must be settled, if or when they sell the property.
Yeah.
Think of it as securing your claim against their assets.
So even if they manage to squirrel away their belongings, you've got this like legal hold over their biggest asset.
Yeah.
Their house. That seems like a pretty powerful tool.
It can be.
But I imagine this process can be a bit more complicated and drawn out.
It can be, yeah. Obtaining a charging order, involves its own legal procedures and costs. Plus, it's only effective if the debtor actually has sufficient equity in the property. If they're already like underwater with a mortgage, a charging order might not hold much weight.
Okay, so far we've got options for going after wages, seizing assets, and even like putting a hold on property.
Mm-hmm. What happens when even those measures don't work or they're just not applicable to the debtor's situation? Mm-hmm. Is there a final, like, ultimate tool in this debt recovery toolbox?
There is, but it's considered a last resort, and it's reserved for extreme situations. An order for sale. As the name suggests, it forces the sale of the debtor's property to recoup the debt.
That's a pretty drastic measure.
It is.
So someone could actually lose their home because of an unpaid debt. That seems like a pretty heavy consequence. It
is, and that's why it's not taken lightly. An order for sale is typically only pursued when all other options have been exhausted and the debt is substantial, It underlines the seriousness of debt repayment in the eyes of the law.
Wow, this is all pretty intense stuff.
Oh.
For anyone listening who might be facing this situation, I imagine it can feel incredibly overwhelming trying to figure out which path to take.
Absolutely.
It seems like seeking expert guidance would be crucial, right? Yeah, 100%. Navigating the complexities of debt recovery requires specialized knowledge and experience. A solicitor specializing in this area can assess your specific situation, advise on the most effective course of action, and ensure you're following the proper legal procedures every step of the way.
Yeah, it's not something you want to try to DIY.
Yeah.
That's for sure.
Yeah.
Getting expert legal advice seems like a no-brainer in this situation.
For sure.
Now, let's say you've done everything by the book. Reminder letters, enforcement attempts, legal consultations, and still the debtor is holding out. Are there any other options at that point, or are you just stuck with an uncollectible debt?
Well, it's true. Sometimes it feels like you've tried every trick in the book and the debtor is still dodging you. But even when those standard enforcement methods come up short, there are still some alternative paths to consider.
Okay, so for those who've reached the end of their rope, what other options are on the table? Is it a matter of cutting losses and moving on? Or are there still some avenues for potential recovery?
It's a tough spot to be in, but it's not necessarily game over. Sometimes the most pragmatic choice, even if it's a bitter pill to swallow, is writing off the debt. This means accepting the loss and closing the case. It's not ideal, but sometimes it's the most sensible option when the costs and effort of further pursuit outweigh the potential gains.
That makes sense, especially if you've already invested time and money trying other methods. Sometimes you just have to weigh the practicality of, continuing the fight. But I imagine writing off a debt, especially like a significant one, can be a tough decision, emotionally and financially.
Yeah.
Are there any other scenarios we should consider before, waving the white flag?
Absolutely. There's always the possibility of the debtor declaring bankruptcy. Now, this introduces a whole new set of legal procedures and complexities, but it doesn't necessarily mean you're completely out of luck.
Bankruptcy. That sounds intimidating. How does that factor into the debt recovery process? Does it just wipe the slate clean for the debtor, leaving the creditor with nothing?
Not exactly. If a debtor declares bankruptcy, you as a creditor would need to register your claim with the bankruptcy trustee. They are responsible for managing the debtor's assets and distributing them among creditors. While the chances of receiving the full amount owed are often slim in bankruptcy proceedings, it's still a way to potentially recover at least a portion of the debt.
So it's like joining a queue of creditors hoping to get some scraps from the table.
Yeah, pretty much.
And I imagine it's not the most ideal outcome, but at least it's a chance to salvage something from the situation. Now, I think it would be helpful to shift gears a bit and look at some real-world examples.
Yeah.
After all, these legal terms and procedures can feel a bit abstract until you see how they play out in, actual cases.
Right.
Definitely. One that sticks with me involves a small business owner who was owed a substantial sum by a client for services rendered. They had gone above and beyond to fulfill their end of the contract, but the client kept coming up with excuses for non-payment. It was a classic case of the check is in the mail, but with a modern twist of ignored emails and unanswered calls.
Ah, the elusive client. A tale as old as time. So what steps did the business owner take to try to recover what they were owed?
Initially, they tried everything you'd expect. Friendly reminders, phone calls, emails outlining the payment terms, even offering a revised payment plan to accommodate the client's supposed financial difficulties. But it quickly became clear that the client was deliberately dodging their obligations.
That feeling of being deliberately ignored can be incredibly frustrating.
Yeah.
So at what point did the business owner decide to pursue legal action and go down the CCJ route?
It was a tough decision, especially since they valued the client relationship and had hoped to, resolve things amicably. But after months of fruitless attempts and mounting frustration, they realized they had no other choice. The unpaid invoices were starting to impact their own cash flow and jeopardizing their business.
It's a delicate balance, especially for small businesses.
Yeah.
Between maintaining client relationships and protecting their own financial interests. So how did things unfold once the CCJ was issued? Did it prompt the client to finally settle the debt?
It did, but not without further twists and turns. The client, upon receiving the CCJ and realizing the potential damage to their credit score,
Right.
suddenly became very responsive.
Okay.
They promised to make full payment within the court-set deadline.
That sudden change of heart is a common reaction. The legal weight of a CCJ often serves as a wake-up call for debtors who might have been complacent or dismissive before.
Yeah.
So did the client follow through on their promise?
Well, initially it seemed promising. They made a partial payment,
Yeah.
which gave the business owner some hope. But then just when it looked like things were finally heading in the right direction, they went silent again. Missed the remaining payment deadline, stopped responding to emails, back to square one, but now with a CCJ on record.
The disappearing debtor strikes again. A frustrating turn of events.
Yeah.
So what did the business owner do at that point? Did they simply accept the partial payment and move on?
Not this time. They were determined to recover the full amount owed. That's when they decided to consult with a solicitor specializing in debt recovery to explore, their enforcement options.
That's a smart move. Seeking expert guidance in these situations is crucial.
Right.
It's not just about understanding the legal procedures. It's also about strategically choosing the most effective course of action based on the specific circumstances of the case.
Yeah.
What did the solicitor advise in this particular scenario?
The solicitor immediately ruled out a warrant of control. After some digging, it turned out this client was notorious for operating on a shoestring budget and renting office space with minimal assets. Sending bailiffs to seize goods would have been a waste of time and money.
That's a great example of why a one-size-fits-all approach doesn't work in debt recovery.
Yeah.
It's all about understanding the debtor's situation and tailoring your strategy accordingly.
Mm-hmm.
What other options did they consider?
An attachment of earnings order wasn't viable either, as the client was self-employed and didn't have a regular paycheck to garnish.
Okay.
That left them with the option of a charging order against any property owned by the client.
The charging order.
Yeah.
It's not a quick fix, but it can be a powerful tool for securing your claim.
Right.
Especially if the debtor has significant assets.
Mm-hmm.
So did they proceed with that option?
They did, and it turned out to be a strategic win. The solicitor discovered that the client was in the process of selling a commercial property. The charging order meant they couldn't finalize the sale without settling the debt. Faced with the prospect of losing the entire sale, the client finally coughed up the remaining balance, plus interest and legal fees.
That's a fantastic example of how persistence, combined with strategic legal guidance, can lead to successful debt recovery.
Right.
It also highlights the importance of understanding the debtor's assets and financial situation when choosing an enforcement method. Not every case will have such a clear-cut resolution, but it's encouraging to see that even when debtors try to play games, the legal system provides mechanisms to hold them accountable.
Yeah, it's a good reminder that even when things feel hopeless, there might be options you haven't considered. Sometimes it just takes a little creative thinking and the right legal expertise to turn the tables.
Absolutely.
Now, on the flip side, I came across another case where the situation wasn't so straightforward.
Right.
And the outcome wasn't as satisfying.
The complexities of debt recovery.
Yeah.
Not every story has a happy ending.
This case involved an individual who had lent a significant sum of money to a close friend.
Okay.
It was a personal loan intended to help the friend through a rough patch with a clear agreement on repayment terms. But as time went on, the friend became evasive, making excuses, missing payments, and eventually ghosting altogether.
It's interesting how often personal relationships become entangled with debt.
Yeah.
It adds a whole other layer of emotional complexity to the situation.
Exactly. They wrestled with the decision for months, torn between recovering what they were owed and preserving the friendship. They tried every avenue to reach out to the friend, hoping to work things out amicably, but their attempts were met with silence.
Right.
Eventually, the financial strain and the feeling of betrayal became too much to bear.
That's a difficult position to be in.
Yeah.
Balancing personal considerations with financial realities can be a real struggle.
Yeah.
So they finally decided to file for a CCJ.
They did. It was a difficult decision, fraught with emotion, but they realized they had to prioritize their own financial well-being.
Right.
And you know what? Sometimes that act of taking a firm stance is all it takes to break through the avoidance and get the debtor to finally engage.
You're right.
Yeah.
That initial legal step can be a wake-up call.
Right.
A signal that the situation is serious and consequences are imminent.
Yeah.
So how did the friend react to the CCJ?
Surprisingly, the CCJ itself was enough to prompt action.
Oh, well.
The friend, perhaps realizing the seriousness of the situation and the potential impact on their credit score,
Right.
immediately reached out and arranged a repayment plan.
That's a good illustration of how the psychological aspect of debt recovery can be as powerful as the legal mechanisms themselves. Sometimes that external validation, that legal acknowledgement of the debt, is all it takes to motivate a debtor to, take responsibility.
It's fascinating how differently people respond to different forms of pressure. Some are motivated by fear of legal consequences, while others need that personal appeal to their sense of responsibility.
Precisely. There's no one-size-fits-all approach to human behavior, and that's why debt recovery can be such a nuanced and multifaceted challenge.
Yeah.
Now, we've discussed cases where the CCJ led to successful recovery, either through direct payment or by prompting the debtor to engage. But it's important to acknowledge that not every story has a neat resolution.
Right.
Have you come across any examples where, despite obtaining a CCJ, the creditor wasn't able to recoup what they were owed?
Unfortunately, yes. There was a case involving a landlord who had a tenant who stopped paying rent and eventually disappeared, leaving the property in a state of disrepair. The landlord obtained a CCJ for the unpaid rent and the cost of repairs, but the tenant seemed to have vanished into thin air.
The disappearing debtor.
Yeah.
It's a frustrating and, unfortunately, all too common scenario.
Yeah.
What options are available to a creditor when the debtor seemingly drops off the face of the earth?
In this particular case, the landlord tried everything to track down the tenant. Hiring a tracing agent, searching online databases, even scouring social media for any sign of their whereabouts. But it was like chasing a ghost. No forwarding address, no known assets, no digital footprint to follow.
So even with the CCJ in hand, the enforcement options we discussed earlier were basically useless in this situation.
Right.
No wages to garnish, no assets to seize, no property to charge.
Right.
That must have been incredibly disheartening for the landlord.
Absolutely. They felt like they had exhausted all avenues, and the debt was becoming a financial burden with no end in sight.
That feeling of powerlessness is understandable.
Yeah.
It highlights the limitations of the legal system, especially when dealing with debtors who are determined to evade their obligations.
Yeah.
What was the final outcome in this case?
After consulting with their solicitor, the landlord made the painful decision to write off the debt. They realized that pursuing further action, like bankruptcy proceedings, would likely incur additional costs with minimal chance of recovery.
Yeah.
It was a tough pill to swallow, but sometimes accepting the loss and moving on is the most pragmatic choice.
It's a harsh reality, but an important one to acknowledge. A CCJ, while a powerful tool, doesn't guarantee debt recovery.
Sometimes, despite all efforts, the debtor's circumstances or deliberate evasiveness make it virtually impossible to collect.
It's a good reminder that thorough tenant screening is crucial for landlords.
Absolutely.
Credit checks, referencing, verifying employment history. These proactive measures can help minimize the risk of encountering such situations in the first place.
Right.
But even with the best due diligence, there's always an element of risk involved.
Absolutely. And that's why understanding the full range of options, both legal and strategic, is so important for anyone navigating the world of debt recovery. We've covered a lot of ground today, from the initial steps of sending a reminder letter to the more assertive enforcement options, and even explored alternative paths like writing off the debt or dealing with a debtor's bankruptcy.
It's been a fascinating exploration of the complexities and nuances of this process. We've seen that a CCJ is not a magic bullet, but rather a starting point, a tool that requires careful consideration and strategic application to be truly effective. And just like any tool, its effectiveness depends on the skill and knowledge of the person wielding it. Seeking professional legal advice is crucial for navigating this landscape, understanding your options, and making informed decisions every step of the way.
Before we wrap up this part of our deep dive, I'd like to touch on something we briefly mentioned earlier, the impact of a CCJ on a debtor's credit score.
Right.
Can you elaborate on that a bit more? What are the long-term consequences for someone who has a CCJ on their record?
Of course. A CCJ is a serious matter, and its effects can be felt for years to come. It stays on a debtor's credit file for 6 years from the date it was issued.
Wow.
And during that time, it can significantly hinder their ability to obtain credit.
So it's like a scarlet letter for bad debtors, making it much harder for them to participate in the financial world.
Well, it's not quite that dramatic, but the impact is real. Lenders see a CCJ as a red flag, indicating a history of unpaid debts and a higher risk of default.
Okay.
This can make it difficult to get a mortgage, secure a loan, even obtain a credit card.
So even if the original debt is settled, the CCJ continues to cast a shadow for years to come.
It does.
It's a powerful incentive for debtors to prioritize clearing their name and restoring their creditworthiness.
Exactly. The long-term consequences of a CCJ can be far-reaching,
Yeah.
impacting everything from housing to employment opportunities. It underscores the importance of addressing debt responsibly and seeking solutions to avoid such a mark on your, financial record.
It's a sobering thought, but a valuable one.
Right.
We've covered a lot of ground in this part of our deep dive, exploring real-world scenarios, discussing the pros and cons of different enforcement options, and even touching on the psychological impact of debt and the importance of creditworthiness.
Yeah.
It's clear that debt recovery is not a simple process,
Right.
but with knowledge, strategy, and the right guidance, it's possible to navigate these complexities and achieve a fair resolution.
Right.
In the final part of our deep dive, we'll delve into some of the ethical considerations surrounding debt recovery. It's a topic that often gets overlooked in the midst of legal procedures, but it's crucial to remember that behind every debt, there are human stories and real-life consequences. So we've spent the last 2 parts of this deep dive, really, like getting into the nitty-gritty of CCJs and debt recovery in the UK.
Yeah.
We've explored those legal tools, the strategic considerations, and even walked through some real-life examples to see how this all plays out in practice.
Right.
But I think it's crucial to shift gears a bit and address something that often gets lost in the shuffle. The human side of this whole process. After all, we're not just talking about numbers on a spreadsheet.
Right.
We're talking about people's livelihoods,
Yeah.
their financial stability, and in some cases, their homes.
Absolutely. It's a valid point and one that's often overlooked in the midst of legal battles and financial calculations.
Yeah.
Debt recovery, by its very nature, involves a complex interplay of rights and responsibilities. And it's easy to lose sight of the human impact when you're focused on the mechanics of the process.
Exactly. So how do we reconcile the need for creditors to recover what they're owed with the understanding that debtors might be facing genuine hardships?
Right.
It's a balancing act, and I imagine it requires a certain level of empathy and ethical consideration.
You're absolutely right. It's not just about wielding legal tools.
Yeah.
It's about approaching the situation with a sense of fairness and understanding. A good starting point is communication.
Right.
Before resorting to legal action, creditors should make every reasonable effort to engage with the debtor, understand their circumstances, and explore potential solutions.
Yeah.
It might be a temporary payment plan, a revised agreement, or even exploring mediation as a way to find common ground.
So it's about treating debtors as individuals with unique situations rather than just entries on a balance sheet.
Right.
It seems like open and honest communication could go a long way in preventing things from escalating to a more adversarial legal battle.
Absolutely, yeah.
But what if the debtor is unresponsive or deliberately evasive? Does that ethical obligation still apply, even when you're dealing with someone who's clearly trying to avoid responsibility?
It does, yeah. Even when faced with, difficult debtors, creditors should maintain professionalism and integrity throughout the process. This means being transparent about the debt recovery process, clearly communicating the consequences of non-payment,
Right.
and ensuring that all actions are lawful and ethical. It's about holding the debtor accountable while still treating them with a basic level of respect.
So we're talking about a firm but fair approach.
Exactly.
No harassing phone calls at all hours, no threatening letters, no showing up unannounced at their doorstep.
Exactly. Those tactics are not only unethical, but they can also be counterproductive, damaging relationships, and potentially leading to legal trouble for the creditor.
Right.
Remember, the goal is to recover the debt in a just and equitable manner, not to punish or intimidate the debtor.
Okay, so ethical debt recovery involves open communication, respectful treatment, and staying within the bounds of the law. But what about those more aggressive enforcement options we discussed earlier, like the warrant of control or the order for sale? Can those ever be considered ethical, given the potential impact on the debtor's life and well-being?
That's where the nuances come in. These measures should always be a last resort, used only after all other avenues have been exhausted.
Right.
And when there's clear evidence that the debtor has the means to pay but is deliberately avoiding their obligations, it's about proportionality. The enforcement action should be commensurate with the debt and the debtor's circumstances.
So you wouldn't send bailiffs to seize someone's belongings over an unpaid parking ticket?
Right. Exactly.
There needs to be a sense of balance and fairness in how these tools are applied.
Precisely. It's about using these tools judiciously and responsibly, not as a means of retribution or inflicting, unnecessary hardship.
Yeah.
And even when pursuing these actions, creditors should ensure that the debtor is fully informed of their rights and has access to legal representation.
It seems like there's a lot of responsibility on the shoulders of creditors to act ethically throughout this process. But what about the debtor's ethical obligations? Do they have a responsibility to engage with their creditors and make a genuine effort to repay their debts?
Absolutely. Debtors also have a moral obligation to communicate openly with their creditors, explain their financial situation honestly,
Right.
and make every effort to repay what they owe. Avoiding communication, making false promises, or hiding assets is not only unethical, but it also undermines any chance of finding a fair and mutually agreeable solution.
So it's a two-way street.
Yeah,
Both parties need to approach the situation with integrity, transparency, and a willingness to find a resolution that works for everyone involved.
absolutely.
It's not just about winning or losing. It's about finding a fair and just outcome.
Well said. And that's why seeking professional guidance from solicitors specializing in debt recovery can be so valuable. They can not only navigate the legal complexities, but also ensure that all actions are ethical and compliant with industry best practices. They can act as a voice of reason, helping both parties find a path towards resolution that minimizes harm and maximizes fairness.
This has been an incredibly insightful deep dive into the world of CCJs, debt recovery, and the ethical considerations that underpin this complex process. We've gone beyond the legal mechanics to explore the human stories, the strategic decisions, and the importance of balancing rights and responsibilities.
Yeah, absolutely.
It's not always a black and white issue, but hopefully our deep dive has provided you with a more nuanced understanding of the challenges and considerations involved.
It's been a pleasure delving into this topic with you.
Yeah.
Debt recovery is an area where law, finance, and human behavior intersect. And it's always fascinating to explore those intersections and shed light on the complexities involved.
And as always, we encourage you, our listener, to continue the conversation. If this deep dive has sparked any thoughts, questions, or even personal experiences you'd like to share, we invite you to leave a comment below. Until next time, keep learning, keep exploring, and keep diving deep.